Hi, good afternoon, everyone. This is Rajiv S. Khanna for Immigration.com, the law offices of Rajiv S. Khanna, PC. Today, March 6th, 2014, is our community conference call. We have one of these every other Thursday. As our announcement in the beginning of the call says, this call does not establish attorney-client relationship and keep your identities confidential. You can make up a name because these calls are publicly available. Okay, let's go over the questions that have been posted. In the beginning, I would like to say something, guys. There is one person who has posted the same question 3 or 4 times, once under a different ID. Please don't do that. What that does is our team basically monitors the number of questions posted. They don't look at whether or not it's the same question over and over again. So we typically close the questions after 18 to 20 questions have been posted. So if you post the same question several times, it takes away from somebody else who could have posted. So please, don't do that again. Let's go back to the questions that have been posted. First, I'll answer the questions that have been posted, then any follow-ups on the questions that have been posted, and finally we'll take new questions. Okay, anybody who has any questions, whether posted or not, we'll take them after that. So help need ASAP says, RFE after first interview for green card, is there a possibility for second interview? My cousin and his wife had an interview a couple of days ago, and today they received a letter from USCIS that they need to submit more documents along with optional DNA testing. Now I'm assuming that one of these couples have been sponsored by a family member, like their parent, and the DNA testing is to establish that relationship. So first question is, since DNA testing is optional, can they skip it? DNA testing is so easy. There really is nothing complicated about DNA testing. I would recommend that you do the DNA testing. Okay, I don't know how good the rest of the evidence is. If you have good evidence, then DNA testing is unnecessary. If you don't have good evidence, DNA testing is a good idea. What are the chances for second interview? USCIS can always call you for second, third, or fourth interview if they like. Okay. Next question is from LALCY Benjamin. Dear friends, there's an H-1B gap in between. After working on J1 for 3 years, I've got a H-1B through the same employer in 2012, which was good till 2015. However, after working for 1 year, I left. I want to come back and the employer is willing to give me a job again. Can I use my existing visa? You can, as long as you can demonstrate to the CBP at the airport that the job was never taken away from you. And let me rephrase that the job is still existing, still available for you. So carry a letter from your employer showing that the same job which was offered to you under the H1 is still open. Okay, that is the way to handle it. Next question, in INTSTU wants to know, I have a question regarding the EB green card through a different employer than where I'm working. So I'm working for employer A on H1. Employer B wants to file my green card, and they are okay if I join them after receiving the green card. Is this legally permitted? Definitely. Definitely. While you're working for employer A, employer B can file your green card based upon their intention to hire you when you get your green card and yours to join them when you get your green card. Interesting thing is, as long as that intention is there, you can actually use AC-21 when your 485 is filed to port off to a third employer and never join employer B at all. That's an interesting fact to remember. Question number 2. If yes, will I be eligible for H1 extension beyond 6 years? Yes. Even though employer B filed your application, you can get your H1 approval extension through A, C, D, E, F, any other employer. What is your suggestion? Just make sure of one thing. That's the only thing that can be a problem in future green card cases. Make sure that the employer has enough financial ability to demonstrate that they have the salary available to pay you. It's called the ability to pay wages issue. Make sure your lawyers look at the ability to pay wages issue and make certain that that is solid and remains solid all the way till you actually get your green card. Other than that, this is perfectly legal. Next question, And this is, Vijaya is the one who posted several times. And it could be because it's a mistake, but you also created a new ID and filed, asked the same question several times. Please don't do that in future. That's not a good idea. It takes away from somebody else. I am on H-1B in 6th year. Currently, H-1B is valid till October 2nd, 2014, including the recapture. PERM is in progress under EB2. PERM application will be filed on April 8th. So, October 2nd, H-1B expires. April 8th, PERM gets filed. That means from October 2nd, 2014 to April 7th, 2015, there will be no work authorization. October, November, December, January, February, March, April. About 7 months, there'll be a gap. Approximately how much time would be needed for PERM approval? Nobody can tell you that. If there is no audit, then there is no supervised recruitment, maybe 8, 9 months, 6 months, 7 months, 8 months. Too many things, too many variables. What are the options for me to continue and get H-1B extended? There are only two options. H-1B can be extended in April 2015, or if the I-140 gets approved. There is no third option. Planning to go to India for 2 months. Will this help? This will only help getting another 2 months H1. It will not help in a drastic way. So you would still have 5 months gap. What are the options if PERM approval goes beyond October 2014? Well, you could go back to school, but try not to do the CPT, curricular practical thing, because schools that give you curricular practical training in the first semester, government tends to look at them with suspicion. Of course, if the school is a good, reputable university, then you're okay. So you could go back to school for a semester, actually for the whole program, or you can go to India. You can work from India. You don't have to, but the work can be outsourced to you in India, and your employer can continue to pay you. Okay, and those are the only two options. Remember one thing, if you are relying upon, and I think there's a question there somewhere, either you posted it or somebody else posted it. So let's say your 1 year of PERM filing gets over, which it does, in April 2015. This is one scenario in which your H1 extension cannot be filed until the 1 year is actually available. So normally you can file 6 months ahead, but in this case you can only file on April 8th, 2015. Just keep this in mind. Okay. Then next one is also the same person, Vijaya. This is from a church. Bill Church says, hiring people from the Philippines to work in Hawaii. While on a recent mission trip from our church here in Hawaii to the Philippines, I met 2 school teachers looking to work here in Hawaii. We currently are opening a school for disadvantaged children, and we'd like to hire these 2 ladies who are currently certified teachers there in the Philippines. What steps are necessary? Move very, very quickly. You can try to get them H1 if they have at least a bachelor's degree, both of them in education or equivalent. File for an H1. Remember, H1 applications require 10-15 days to prepare, and April 1st is the deadline. You don't get them filed on March 30th to reach March 31st. To reach USCIS on April 1st, you could lose this year's quota. H1 is one way to look at it. So H1 visa appears to be the most reasonable option. Try that. Now, if they were religious workers, I would have suggested something like an R visa. Another option is if they can come for some kind of a practical training on a J visa, which is a longer shot. Try for the H1 first. Okay. Next question is from Kiran, use of old H1B. I came to US in December 2007 with L1B, got an H1B approved but didn't join them, told them to revoke it. Can I use my old H1B with the same company or different employer under cap exempt? And the answer is yes. As long as, let's see, they filed an H1B in April 2012. So that means your H1B was filed within the last 6 years, so you are not subject to the quota. Can you use the same old H1B? If it has been revoked, you cannot use it. It's got to be reapplied. However, you should not be subject to a quota, whether you go with the same employer or some other employer. Next question is from Leo. Parents both lost green card in the United States. Can we expedite this process? 5 months have passed. The answer is try going through a congressman's office. Maybe they can find out what's going on. But if parents want to go to India, which is what you said they do, they can always get a stamp on their passport, which will allow them to travel. Okay, so what they need to do is they need to make an appointment, an InfoPass appointment at the local USCIS office, and tell them at the USCIS that we want to travel and an application for a replacement green card is pending. They should be able to get a stamp on their passport, which should be good for between 1 and 2 years, which will allow them then to travel. So traveling is no problem. Okay. Next question again is from Vijaya. So she has one more addition. By what date should I re-enter in USA so as to apply for H1B extension? I'm not sure I follow that question. I think, Vijaya, one thing I want to point out, a lot of people even now are under the mistaken belief that in order for them to apply for H1 extension beyond 6 years, they must be on H1 status. That's not true. Even if there is a gap, so let's say my H1 runs out today and I want to apply, I become qualified to get H1 extension 6 months from now, I can get an extension even though I'm not on H1. Maybe that's your confusion. Rajesh says, R Kata to 2011, H1B transfer after I-140 withdrawal. So in his case, what has happened is, from his previous employer, he got his I-140 approved, transferred to employer B, and got his 3-year extension till 2015. The previous employer withdrew the approved I-140. Okay. And the new employer, employer B, is now starting the green card process. So the questions are, number one, if I get another offer from company C, does my H1 transfer get approved? I don't think so, because the I-140 is not active. As far as I know, and I would like to be corrected if I'm wrong, I don't think you'll be able to get an extension because the I-140 is no longer active. Number two, what are the chances if my new perm started now is rejected after 12 or 24 months? Well, you know that if perm is rejected, you can file an appeal. While the appeal is pending, which is 3.5 years, you can keep getting H1 extensions. In the meantime, you can start a new perm process and time it so that you withdraw the appeal and file a new perm in such a way that you still have enough H1 left to keep getting H1 extensions based upon a new filing. It can be done like that. Can my old employer still has a chance to resubmit new I-140 based on old perm? I think they do. I think they do. I don't see why not. I mean, this is a gray area of the law where nothing says that they cannot do it, but I think they can. Personally, I don't see any problem with it. Travel on advanced parole, Priyanka, who's Priya C123. I've applied in November 13th for green card for my mother, concurrent processing. That means I-130, 485. Got the advanced parole approval. She'll also probably get an interview waiver. And so the process might be over by July 14th or so, July 2014. For how long can she visit India? Can she go for 3 months? Yes, as long as the advanced parole is still valid. Within the life of that, she can be outside the United States. When filing her AP application, we had written that she would visit for 30 days. Can she go for longer duration? Yes. Will it be held against her? I don't think so. What happens if the green card gets approved while she's still in India? It happens all the time. If the green card gets approved while she's in India, she's got two choices. I like the first one better. She can travel back on the advance parole. At the airport, they will know her green card has been approved, but they will let her enter on the advance parole. Not a problem. Second option, people get their green card delivered to them in India or in their home country, and then they travel on that green card. I don't like that option. I like the advance parole option better. Girish123 Sabari has a question about green card in L1A without degree. Giriji, you had also, I'm pretty sure you had written a message on immigration.com in one of the questions, and I've answered this question for you. I'll do it again. 14 years of IT experience and performing manager. Service delivery role for the past 3 years, planning to enter USA on an L1 visa. He's supervising 30 people working in India, China, and USA. I already worked and stayed in USA for 5 years on L1B. After 1 year stay outside, he's going to come back in again. So question number 1, how long I need to wait to initiate the green card process? And I answered that question. There is no waiting time. You can process it anytime you like. Do I have a choice of selecting EB1 versus EB2? Yes, but why would you want to do EB2? That takes 7 years or 6 years. EB1 is immediate. I don't have a bachelor's or master's degree. Actually, EB2 may not be an option. EB3 would be your only option, EB1 versus EB3. I don't have bachelor's or master's degree. Will that be a barrier for applying green card? No. EB3 is any job that requires a bachelor's degree or at least 2 years experience. So EB3 does not require a degree alone. Should I apply only through my employer or can I apply myself? You have to go through your employer. I don't see a case for self-application. Next question is OGL 2014, employment-based green card and intent to stay with the sponsoring employer. So he's working for employer A or she's working for employer A for the last 9 months, applied for EB1B, which is I guess outstanding researcher-based green card in July 2013. Just after filing I-485, employer B contacted me with a job offer. Emailed employer B expressing interest. Now that email would be in the possession of employer A. So I've got my green card in December 2013. What if I leave in March? Could this be a problem if the employer reports me, especially because they have an email that says I want to join? Look, my guess is it should not be a problem. Technically, can they create a problem? Can USCIS make this a problem? They probably could. They could take the position that when you took the job in December 2013 on your green card, you had the intention to leave already. Okay? But you can always refile the EB1B through another employer if necessary. I don't think it'll come to that. Bottom line is, my guess is it's not going to be a problem. That's my guess. Can I guarantee? No. Can USCIS make it into a problem? Yes. What would I do if I were you? This is a personal, not a professional matter. I would take a chance. I think chances of things going wrong are rather small. Amna Nadeem. Question about dependent status. She has an approved I-140 under EB3. Husband and 3 children have been filed. The daughter is 20 years old and she's married in December. I think once you get married, you can no longer be considered to be a derivative. I could be wrong. I haven't looked at the law for a while, but my suspicion is she's already out of the dependent or the derivative status, as far as I know. Double check this, please. Okay. So it's not the being pregnant. The fact that she got married, that's what takes her out of your green card. Double check that. But being pregnant is not a problem. Kirti Prash. Date of birth mismatch. So here what happened was, there was a date of birth in the paperwork which is different from the date of birth on the birth certificate. Okay. Father said he did this to put Kirti in school earlier. What should I do? Don't worry. What you can do is discuss it with your lawyers. They can get an affidavit from your father and from you, and basically they should use the real date of birth as your date of birth. Get a couple of affidavits from people who know when you were born. Um, I think you should be okay. We've had this kind of a situation. Unfortunately, it is rather common in India for us to inflate people's ages so that they can go to school early. Abhishek Verma, 6 years H1B over November 2013. How long to wait before I can apply in H1B quota? I think it was Abhishek's question. So you cannot apply for an H1 extension based upon 1 year perm pendency until the 1 year of the pendency is over. You cannot apply. So if your perm was filed on April 14th, 2013, you cannot apply for the H1 before April 12th, 2013, 1 year. Other cases you can apply 6 months ahead. But where it's pendency for 1 year, it has to be finished. Otherwise, they'll kick out the application, they'll make you file again. So questions. Can I re-enter on H1B after having spent 365 days outside the US? Yes, you can. Make it 366 days. If I come to the US on any other visa, visitor F1, before the 365-day period, I won't be able to apply for H1. No, you won't. You've got to finish the 366 days. I call it 366 just to be on the safe side. Also remember, if you enter the US on a tourist visa for 10 days, then you have to spend extra 10 days outside. But if you enter and stay too long, you might have to start the 1 year all over again. So let's say you were outside USA for 7 months and then you came to USA on a tourist visa for 6 months. You might have to start 1 year all over again. Okay. Number 3, a company who I am liaisoning with wants to apply for my H1B. They said they can only apply for H1 6 months into my 365 days. That's wrong. You have to wait the whole 1 year. To apply for H1B, does the company need to show job offer, contract? Absolutely. The company must have a definite project or in-house project for you. Without that, they cannot file. They should not file. Are you quota exempt? If you have been outside USA for 1 year, you are no longer quota exempt. But because you're doing an extension, let me think about this. Are you still under the quota? I don't know the law on this issue. I've never really thought about this. My extension is coming based upon my perm having been filed. Maybe you can come under the remainder option and not be subject to the quota because you are taking a 7th year H1 extension. Interesting point. I think there is an argument for being quota exempt. I would have to check the law carefully, but I think there's an argument for being quota exempt, even though you've been outside USA for 1 year. Okay. If a company applies for my green card while I'm in India, would the process be any different than if I were in USA? No. You can definitely do that. I mean, for you, the process will be pretty much the same. Arya Turi, prior deportation background check. If client thinks they were fingerprinted when crossing illegally by Border Patrol, where should these prints show up? US DOJ, FBI? Oh, I think this is another lawyer. Well, Arya, what you should do is file a Freedom of Information / Privacy Act request with Customs and Border Protection. I would think that CBP is the first line. With ICE, that would be the second line. And with USCIS, all three. Not with FBI, because unless there was a criminality involved, illegal entry is not a criminal offense by itself. Deportation is a civil proceeding. Removal is a civil proceeding. Exclusion is a civil proceeding. So FBI would not get involved unless there was some false documents, forged documents. Your best bet, in my view, and you can file FBI request also. These don't cost any money. So you can do, I would do a CBP, Customs and Border Protection, ICE, Immigration and Customs Enforcement, and USCIS, and perhaps also do FBI, but no DOJ. Fun dude. EAD renewal delay. So the problem here is this. It's been more than 100 days since I applied for renewal of my EAD. Okay. Now, there's no expedite. So the question is, in case I don't get my renewal in time, can I go on paid vacation? You cannot. You could go on paid vacation, or, well, let me tell you what EAD does. EAD allows you to work and or get benefits. So if you went on a leave without pay and without any benefits, that's no problem. Can you go on paid vacation? Only if you have already earned that vacation. So let's say you have worked for 1 year and the employer's policy is they give you 4 weeks paid vacation. You can take that because you've already earned that. Okay. I understand your frustration. Why should they impose a time limit? But that's what we are dealing with. Not a perfect system by far. Okay. It's the same question under a different ID. This is Vijaya again. This really irritates the hell out of me. I'm very sorry to hear this. This is a sub coach who's got a very, very bright son who's got a presidential scholarship, which they may not be able to get because they don't yet have the green card, but their 485 has been pending. Question is, what should we do? You know, I would talk with the scholarship body. Talk with the scholarship body and say we are so close to the end of the green card process that there should be an exception made and it should be considered to be all but green card. So that's the best you can do. I know that we had an issue like this many, many years ago, 10, 15 years ago. And if you go to the forums, there are some discussions about that. And I remember being very actively involved with that issue at that time. Similar situation, parents who had children, excuse me, I need some water, who had children, school-going children, who were going into college, and the scholarships were not available because they didn't have green cards, but the 485s were pending. And if I remember correctly, in those cases, those particular bodies made an exception. Okay, so you can look into that. I think that's the only option you have. Okay. Next question is John. Oh, by the way, you should also contact your congressman's office. Okay, see if they can do anything for you. John J. So there was a green card interview. Everything was nice, happy. Officer asked the poster's husband about his date of birth. He was nervous and he messed up the date, but he gave the correct one later on. I don't think it's that big a deal. Okay. Then again he asked how long we knew each other. Husband fumbled. He was just nervous. Asked few minor questions. Attorney said the interview went very well, and we felt like that too. Next thing is the case was denied. So my questions are, that's what she says. Is it possible it can be a mistake on the site? It can be. Because I think before they deny the case, they should have sent out a notice of intent to deny. That would be my guess. That is the normal process. It's my husband's second marriage. Officer did not ask him about his previous marriage. Current student status. My current student status ends March. Do I need to renew my status? Okay, I'm a little confused. I guess it's the husband who is a US citizen. I can only guess. Okay, yeah, definitely. My current student status ends March mid this year. Do I need to renew my status? You know, it's interesting. USCIS has said if you file 485, we do not consider you to be able to maintain F1 student status at the same time. But if I were you, I would keep my status active. You never know. Can I use my EAD? Oof, If you want to be aggressive, yes, I would just continue with the student status. If we file an MTR, how long can the process take? I don't know what the grounds of denial are. If it's just a 485 denial, you can only do an MTR, there is no appeal. If there's an I-130 denial, you can do an appeal to the Board of Immigration Appeals. And the process, you'll have to check out the processing times from Board of Immigration Appeals website, BIA. Okay. We strongly believe this is a clerical admin mistake. Can we expedite this? I personally feel that there is something odd here and it should be a mistake, and I'm hoping it's a mistake because they did not send you a notice of intent to deny. So what is the point in worrying until you know for sure what's going on? And if the marriage is in good faith, it's a bona fide marriage, I think ultimately you will win. That is my belief. Okay. Page 123. I'm currently in India and I have 3 years of H1 stamped. My EB3 I-140 is approved. Priority date is 2012. Currently there are no projects within my current company. Can some other company do my H1 transfer while I'm in India? Yes, they can. I've been in India for 3 months now and I don't have pay stub. That's okay. That's not a problem. Once H1 transfer is done, can I reuse my current stamp? My understanding is consulates want you to go for stamping again in these kind of cases. Okay, so if I were you, I would go for stamping again. Ang_query. Got married in 2009. Wife came in on H4. She filed for H1B in 2011. Then she got pregnant, had a baby in April 2013. Then she did not continue work for health reasons. We planned to convert her to H4, but then that got delayed to different reasons. We want to convert her to H4. Which is the best way? I don't think you have a choice. It looks like she's been out of status for too long. She should go outside USA to get H4 visa stamping. That's what it looks like to me. Is it better that I accompany her and we get H1B and H4 together? My H1 stamping is also due. It's not required unless the consulate insists that you get your H1 stamping. And don't be worried about her previous status. You should be truthful about it. The fact that she was out of status on H1 should not be a ground for denial of the H4. So be truthful. Okay. Sunil R. Kimi. That's the last question. Then we'll take follow-up questions and then we'll take new questions. Question about H4 stamping, port of entry with change of employer. I am on H1 with employer A. My wife is on H4. Both stamps have expired, but I-797 is valid through 2016. Wife wants to travel to India, let's say on April 5th. I'm in the process of switching employer and I will switch around April 15th. She plans to be back on May 5th. So while she's gone, he'll be switching employers. Can she get an H4 based on my current H1 with employer A and travel back when I would have switched to employer B? Yes, I don't see any problem with that. No, there should be no issues on the port of entry. If the above is true, would that visa stamp of H4 be valid if she travels again, say in 2015? Yes. Yes. Your change of employer should not affect her H1 visa, her H4 visa. My new employer A's attorney said they don't need to do anything because she is still good till 2016. They are right. That is the correct understanding. Okay, let's do new questions. Let's do follow-up questions. Anybody who has already posted and has a follow-up question, press *5 on your phone. *5. No new questions, just follow-ups. *5. Okay, only one follow-up question so far. Only one question? All right. Houston, Texas. Go ahead, please.
Hi, mine was a thing with regard to the H1 to H4.
I'm sorry. Your,
My,
your your voice is cutting off. Can you point me the question number?
okay, it's the second last question.
Second last question. Okay,
The
one
one
second.
regarding,
H1B to H4. She was working. She got pregnant. She's out of status. What is the best way to convert her to H4? Right?
yes,
Go ahead, sir.
yes. So the situation now is that she's ready to resume work, and the employer also has got a project for her. Do you recommend that if she works now, and let's say for 4 months, and then she has pay stubs, that we try for a change of status while here in US itself from H1 to H4 with the pay stubs
No,
that she gets?
no. I do not recommend that for a number of reasons. That's like whitewashing a broken fence. Okay. Correct her status. Let her come back on H4. Then apply for change of status.
Okay, okay, okay. Thanks, Rajiv.
Good luck. Okay, anybody who has any question, new, old, follow up, doesn't matter. Press *5 on your phone, please. Oh, this is easy. 3 questions only? Ah, those I can do easily in my sleep, right? Oh no, there's more. 4. Okay, I'm waking up. All right, guys, let's start with, in the order that you guys logged in, let's start with Washington State. Go ahead, please. Area code 425, Washington State. Go ahead. Area code 425 328.
Yeah, this is it. Hey, Rajesh.
Yeah.
Hey, Kana.
Yes.
Yeah. Yeah, my name is Srinivas.
Yes, sir. How are you?
I have a question. Like, my COS, change of status, was filed on October 3rd.
Okay.
Sorry, my change of status was received on October 4th,
Okay.
but my H1 was expired on October 3rd.
Okay.
So, does it make any difference for one day?
Yes, it does. You are now out of status and you are
Okay.
unlawfully present in the United States. If you stay unlawfully in the United States for 180 days, you will be barred from entering the US for 3 years if the H1 is not granted, okay? Also, you're also not authorized to work. If the H1 had gotten there
Okay.
before your status expired, then you had automatic permission to work for up to 240 days, almost 8 months.
Okay. So what I'm supposed to do now? So if my, this is H4. If the H4 got approved, so I can stay, right? After 180 days also?
Be careful, because if for whatever reason the H4 gets denied, I didn't realize it was an H4. If the H4 gets denied, then you will have the 3-year bar. So be careful. You may want to just go outside USA, get an H4 visa stamp and come back.
Okay. Okay.
Okay? Good luck.
Thank you. Thank you.
You're welcome.
Thank you.
Okay. Let's see. Minnesota. Minnesota, go ahead, please.
Yes, Rajiv, I am a naturalized US citizen
Yes.
and I would like to file a green card for my parents.
Okay.
The problem that I have is they do not have birth certificate and they are from India or citizens of India.
Okay.
They do not have their birth certificate. They do not have their marriage certificate either.
Okay.
and I tried, but it's extremely difficult for me to get a non-availability certificate for their birth as well as their marriage. The only thing I can try and get is an affidavit from relatives, but even that is going to be tough because they both are close to 80, almost 80 years old, and a relative that is older than them who can testify that they were born at a certain date and they were married at a certain date is very remote. So what are my options here, Rajiv?
Okay, first of all, if you don't mind spending the money, get yourself a lawyer, because this tends to get a little cumbersome. It's not rocket science, but it's just paper intensive. What does our office do in cases like this? First of all, on the birth side, we tell them that look, we have nobody in India who can go to the local municipal corporation and knock at their door day in day out to get a non-availability. Okay, we give them an affidavit like that. We give them affidavits from two family members or two friends who were alive when they're born. Alive when they're born. Okay, and if we cannot even do that, we make an offer, do our DNA testing. Okay, along with that, we give secondary evidence of all kinds, hospital birth certificates, school certificates that show both parents' names, ration card which shows all members of the family, pictures of the family together. Secondary evidence can be given if primary evidence is not available. But it gets tricky, it gets cumbersome, so I would want you to get a lawyer. Okay?
Okay, thank you, Rajiv.
You're welcome. Good luck.
Thank you.
Okay, two more questions left. This ID is blocked, so I don't know. I don't know who you are. There's only two people left with their hands up. Can you both say hello? One of you is this person.
Hello.
Yes, go ahead, please.
I transferred my H1B from company A to company B in April 2013 and since then it's pending in background check. Though we have to give it to premium processing.
Okay.
So I'm still working for company B and my paychecks are with company B. It's been more than it's almost a year, like we filed in April 2013.
Okay.
So now my spouse wants to go to India. So can I go back to company A and work for them, and if I on their pay stubs can my spouse go to India and then have it for stamped?
In my opinion, you cannot now go back to company A because you've already shifted over to company B. I do not believe, and I don't have any legal authority for this. I really cannot tell you.
Company A.
Yeah, I cannot tell you there is an.
Company A.
Ma'am, can I finish what I'm saying?
Company.
Ma'am, can I finish? Can I finish my thought, please? Let me finish. Okay. In my view, if you have gone from company A to company B while the application for transfer over to company B was pending, you can no longer go to company A again. That's my view. I do not have any legal regulation that I can point you to. Okay. Technically, the moment you leave company A, they should have revoked your H1. They haven't done so. Can you use it? My conservative, perhaps very, very conservative view is you should not think about that as a good option. It's an area of the law that leaves me very uncomfortable. I don't have a bright line rule on this. Now, if you have a visa and company A has not revoked your H1, you could go outside USA, even if you go to Canada or Mexico, and come back using your visa stamp. You can then go and work for company A again. But under the circumstances, I don't think you should go back to company A. Go ahead, ma'am.
Still my name for is there till September 2014. Still it's not good to go back, right?
That is correct. In my view, it is not good to go back.
So then It's like if my spouse can go for stamping because company is still pending in background check.
They cannot. Your spouse should not go for visa stamping, in my view. It's going to be very tricky at this time. Okay? Sorry. Good luck. Okay, last question of the day from Georgia. Go ahead, please.
Yeah, hello Raju, good afternoon.
Good afternoon, sir.
Yeah, I have basically two questions. One
Okay.
for GC and another for H4.
All right.
Okay. About the GC, like I came here on 2012.
Okay.
And I have like 10th diploma and 20 years experience. Company is willing to file or to start my GC process, but I want to know under which category they will start my process. Is it KB2 or KB3?
Your education qualifications are a diploma.
Correct.
Um,
Diploma and 20 years experience.
No, right, I understand that. Education qualifications is a diploma. And the diploma is a three-year diploma. What kind of diploma is it?
Yes, correct. It's a 3-year diploma mechanical.
Oh, yeah, okay. It appears to me, my best guess is you have no choice but to go through EB3.
Okay. That means they won't calculate experience is equivalent to educational year.
Only for H1 purposes they do. For green card, they do not.
Oh, okay. Okay, no problem. The second question is like for the H1. Now, myself and my wife, we both are having H1, but with different employers.
Okay.
And my son who is dependent on H4 visa, that is on my H1. But my wife and my son, they're trying to go to India in coming May. So now they have to stamp their visa because it's based on the exchange of status, she is having H1. And again, based on the change of status, my son is also having H4. That means they don't have visa stamped on their passport.
Okay.
So how my son will have H4 stamped on my H1 visa or maybe the with wife's visa?
He has a choice. He can go with either one.
Okay.
Remember, just because he has a change of status approved through you does not mean he's stuck with your H1 application. At the consulate, he can decide to go with your wife's application or your application.
Oh, okay. That means currently at present he is on H4 with my status. It won't calculate if he is in India with my wife's H1.
No problem at all.
Okay, that means smoothly he can go for H4 with my wife.
That is no problem at all.
Thanks. That's these are the questions for myself. Thanks.
Very good. Good talking with all of you folks. I will see you next Thursday, guys. Bye-bye.
Bye-bye. Thanks.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.